themselves for the record, starting with disciplinary counsel.
Jack Metzler for the Office of Disciplinary Counsel, and Phil Fox, Disciplinary Counsel, is here with me.
Good afternoon. Excuse me. Johnny Howard, representing the respondent. It's Iris McCollum Green, and she's present.
Good afternoon, Iris McCollum Green.
Let the record show that board member Ms. Rice Hicks, who is one of our attorney members, is not in attendance today. Our board rules, Rule 13.6 allow an absent member to participate in the decision of the board by listening to the recording of the oral argument absent an objection from respondent. Does either party object to the participation of our absent board member in that manner?
We do not.
We do not.
No objection noted, thank you. Let the record also show that board attorney member Michael Tiger is participating remotely via Zoom. We are here on exceptions to the hearing committee report from both respondent and from disciplinary counsel. Have the parties discussed who will proceed first? If not, have you discussed? If not, respondents' exceptions raise the most issues. So that party will proceed first. Mr. Howard, you will have 20 minutes. Do you want to reserve some of your time for rebuttal? If so, how much time?
Would like to reserve 5 minutes.
5 minutes? Okay. Please proceed then, Mr. Howard.
Thank you. May it please the board, we are here to make sure that the full record is reviewed regarding what transpired at the hearing committee. I'd like to start with 6 concessions that are evident in the hearing committee report. First, on the question of harm to the client. After all discovery filings, all motions, all the years of investigation, the committee wrote the following. We agree with respondent that disciplinary counsel did not establish by clear and convincing evidence that Mr. Berry, the client, actually would have obtained a more advantageous result had the respondent met the standard of care. And that's in quotations from the committee. Secondly, the timeliness of the answer to the underlying complaint, the committee found, we find that disciplinary counsel did not establish by clear and convincing evidence that respondent's response was late when she filed it. Third, on the question of whether a respondent knowingly disobeyed court orders, a Rule 3.4C charge, the committee found, we find the respondent did not knowingly violate the court's orders. Fourth, on the dishonesty charge itself, the committee declined to find flagrant dishonesty, the standard that would have.
Mr. Howard,
Yes.
how is the lack of a finding of flagrant dishonesty relevant to whether or not there was a finding of dishonesty or misrepresentation, and there was a finding of a violation of 8.4C. So how is the failure to find flagrant dishonesty relevant to our proceeding here?
Well, it's irrelevant in this way. If there were a flagrant violation, then the argument advanced by disciplinary counsel for fitness would come into play. We will deal with the finding of dishonesty, but it's important that we distinguish between the two. And that was the distinction that was sought to be made. And fifth, the committee found we have no serious doubt about respondents' continued ability to practice law. And sixth, we find the disciplinary council failed to prove that respondents' misconduct arose from her lack of competence in her area of practice, domestic relations law. Now, we believe that if you take,
Mr. Howard, would you consider compliance with discovery obligations part of the attorney's competence in divorce proceedings?
certainly, but in this particular case, it's not only whether or not the attorney, handled discovery properly, but it's also at least two parts. Was the discovery that was produced, did it evidence that there was a failure of any violation of discovery rules? And then secondly, was there evidence that the client may not have given to the lawyer all that was needed for, let's say, a more robust response to discovery?
There's clearly no doubt that discovery was produced. But what seemed to be a problem that the court found repeatedly is the failure to identify what had been produced. There was no real system or indexing to help the court or to help opposing party find out what was actually produced. Isn't that part of the discovery obligation?
Well, that certainly is part of the discovery obligation. But you must remember, in the court's order, after some back and forth between the lawyers about the content of responses, the court established that, and we call this a neutral area, where the discovery would go into and there would be a level of transparency. And that was the order regarding use of Box.com. And that is the vehicle that the respondent used to make sure that her items were in the box. And they were in the box and they were labeled.
Well, the court seemed to have a problem with that, though, identifying the documents and being able to obtain the documents she requested because of the lack of indexing.
Well,
That seemed to be a big problem in the court's mind and in some of the rulings, a number of the rulings. Is that correct?
but that's not quite correct, because if you look at the rulings that were made, there's nowhere in the record that anyone ever analyzed what the respondent said was in the box. And so if you don't analyze the content of what's in the box, it doesn't appear to respondent that there can be an analysis of some level of either violation of discovery rules or violation of so-called incompetence. That was not the case. So it's very difficult when people are talking about a thing, but no one looks at the thing to determine, was the caliber and quality of discovery items in the box? That was supposed to be the transparent vehicle for which the court, as well as the parties, would be able to see what was produced and the quality of it. And that was never done. The client inserted the documents into the box.
That's what was in satisfied the court or the hearing committee in this disciplinary proceeding that the materials had actually been clearly identified and were produced. You're saying it's an analysis that was never done. I'm asking, did your client undertake the analysis?
Yes. I mean, the documents were inserted in sort of two ways in terms of identification. The respondent inserted the documents. There was a listing of the documents that were in the box with exhibit numbers. And so those were listed on a document and the exhibit numbers were affixed to the actual items. The respondent's client entered some additional documents. He identified those documents by giving the file name a description. For example, I can't remember the exact correct.
Whether all this is explained to the judge in the underlying action to satisfy the Superior Court judge that these steps have been taken and we're complying with the order.
I don't know exactly sort of how it was couched, but both the respondent and the respondent's client indicated to the judge that the items were in the box on different times that there was an inquiry made.
Mr. Howard, it's our understanding that the judge scheduled several hearings and was looking for the opportunity to discuss with your client exactly what was being produced in discovery, but yet the judge was never satisfied with her answers or what was produced, or that it was produced in an understandable, organized way as expected. It sounds like you're saying that those hearings that the judge was scheduling were unnecessary because the way your client produced the materials was satisfactory. Is that your position?
My position is if one looks at the documents that were in box.com, you would see an order of organization. It was not disorganized. And so the order of organization that the respondent understood was that that was available to the judge, and at that time, Judge Wingo. And so the hearings didn't always go smoothly, but the information was present, and no one really looked to see whether or not there were defects.
That would be from the point at which the judge ordered the box.com to be used by your client going forward, but that's with respect to the period of time before the judge told your client, instructed your client to use the box.com app or whatever it is. There's no indication, is there, of organized production? The record indicates that there was no organized production, even assuming that there was post box.com.
Well, I think the way that the box.com came into existence was that the respondent requested that the court allow her box, being familiar in this practice, to allow her box to be available for insertion of documents. The only analysis, so to speak, if you will, was from the opposing counsel. He was the one saying that this was not done and that was not done. But there was never a third party to look into the box to see if it was there. Now, with respect to the documents that were produced before the box.com, they were produced in the box.com once the box became open. So all of the discovery that the respondent made for this case ended up in box.com.
Let me understand the argument here with respect to the discovery and production. Can you address the other findings and conclusions of the hearing committee that rely on findings of failures to appear, failures or missed deadlines, and failure to adopt technology? Leaving aside your arguments with respect to discovery, there are other significant allegations and findings here. So, for example, missed deadlines. Right.
One of the aspects I think that was certainly appreciated by the hearing committee, and that is the effect of COVID, the pandemic, on just the overall presentation of a case. And in this particular instance, at the time that the height of discovery was taking place, the defendant was not in a position of being able to, go down the hall, across the street, or wherever to get certain information. And so all of the discovery that was taking place was done with persons not sitting next to each other, but one communicating with the other and then pushing out a finished product. And so in that regard, there were some hitches and glitches. It wasn't intentional, but there were there were some unintended consequences that resulted. Now,
What about this?
I understand there are some unintentional consequences, but the court forgave late filings of the answer because of COVID. But the other matters happened down the road, discovery, and that extended for over 18 months until there finally was a default judgment.
one of the things I think that has to be appreciated, and that is, what was the quality of discovery that was produced? And that's not really clearly identified other than conclusory statements that this wasn't produced or that wasn't produced.
Mr. Howard, if your position is that respondent was producing quality discovery, isn't that her obligation as the attorney to convey to the court in a clear manner that the quality of the discovery is sufficient to meet the court's expectations and to meet the rules around producing discovery?
I believe that that is certainly true. However, there were statements both from the respondent and her client about specific items that had been produced. And there was a disagreement with opposing counsel. That disagreement was never evaluated to see yes or no. It was more statements taken as being truthful by the opposing attorney.
Mr. Howard, the chair asked you about missed hearings. Could you explain how the board should react, for instance, to the board hearing on December 20th, which was basically to discuss the default judgment that had been entered earlier? What is the explanation?
Well, I think the record is clear about the explanation. The respondent, did not have that particular item on her calendar.
There were repeated emails, and it was included in the December 19th default judgment when it was released for writing, again with that date. So all of that was not observed or paid attention to?
Well, if you recall, that December 19 email was on a Sunday.
Correct.
And that is not an email that the respondent saw until the next day after the time for the hearing.
This is the December 20th date that your client originally suggested for the hearing?
There was some back and forth in terms of how that date came about. When I think there were probably even more dates than December 20th. The respondent indicated that she and her client were available for the hearing. And almost instantly, the opposing counsel, that's not a good date for me. And so that removed it from a time when sort of everybody was, let's say, in a cluster, to a point later on where the opposing counsel indicated that he would be available.
For the time in question that we're considering, Mr. Howard, what does the record show about you, how and how often your client checked her emails?
Well, it's a bit mixed. There were instances where, items came through and the email was checked almost instantly. And then there are some occasions where there was a delay.
Well, sometimes a couple of weeks.
I think there was only one instance.
Let me move on for at least at this point to the filing of a quote unquote joint pretrial statement.
Yes.
By your client, to which she affixed the initials of opposing counsel and otherwise indicated that he was joining in that statement. How is that not a misrepresentation to the court?
I think it is It just seems almost impossible for one to perceive that as a misrepresentation. And this is why I say that. The document, if you look at prior documents that were being traded between the two lawyers, and when you have to, produce a joint pretrial statement, both the rule as well as the court's order was that it was a requirement for a joint pretrial statement. The first draft of the joint pretrial statement, I think, was about at nine something in the morning. The respondent produced her input at about 11 a.m. in the morning. There was a proviso that if I file an addendum, then I'll let you know. That generated some back and forth between the two lawyers. But the actual document was pretty much put together at 11 o'clock when the respondent added her section. Later on, when the joint pretrial statement was filed, it was no more than that document that came from both parties at 11.
Mr. Howard. But didn't your client indicate that she was going to file the addenda without having Mr. Markowitz review it?
That just
That's what prompted this exchange of emails, which is pretty well documented.
I think the one thing that's missing from this, when you say that she was going to do something without him taking a look at it, that was not the import of the email. And that has never been, if you look at just all of those discovery disputes and battles, there was never an indication where the respondent indicated that she would not cooperate. It was always from Mr. Markowitz indicating, I need it done at this time, or I want it done this way. It was that kind of scenario. If you notice, even more so, there is a difference in the way the court or the trial judges handle the case. Judge Wingo's style was a little bit different than Judge Higashi. There was none of this back and forth with Judge Higashi. And the case proceeded and went on.
To go back to that, though, the exchange that went back and forth on that day, at one point in time, at 4 o'clock on that day, Mr. Markowitz filed a statement. It was just for his client.
Correct.
Now, according to the hearing committee, Ms. Green, respondent, got notification that did not open it, but sent an email to him saying, if you submitted something without my approval and with initials and a slash or slash and an S, that is unethical. And it wasn't until midnight when she actually opened the document and saw it was not joint that, quote, she panicked and then filed her joint statement. Is that correct chronology?
Well, that's pretty much a correct chronology. Once I think the filing notification would have come through, I think, Case File Express, and the document was identified, and so the respondent believed that the document that had been submitted was the document that they had been working on.
And she indicated, though, that joint document, if it bared her initials, it would be unethical.
No, it wasn't initials. If it bared her signature.
Well, it was in her email, and it was /S/.
Correct.
Okay.
And that's part of what we have contended with respect to that joint pretrial statement. You do not have a party's signature on it unless it has the electronic signature /S/.
But Mr. Howard, help me understand this. So opposing counsel ends up filing their own statement. And to that statement, they do not affix any initials or names of your client. But later, your client, when realizing that the statement was not a joint statement, affixes opposing counsel's initials and then puts their name in full in certificate of service, and then files it as a joint statement. Did opposing counsel for that statement your client filed give her the authority to file that as a joint statement, as a statement that he was signing on to?
I think you have to look at there are two parts to this. One, you have an order that says you file a joint pretrial statement. And generally, in most judges, if you don't file a joint pretrial statement, they have you to go through the process over again. But this joint pretrial statement happened to be the exact language that Mr. Markowitz sent to the respondent at 9 in the morning on that previous day from 9 in the morning for that day that was later filed at 4 p.m. But the 4 o'clock pretrial statement didn't even bear any indication that there had been discussions in between the parties about generating a joint pretrial statement. So the statement, when it said joint pretrial, all of that language was language in which Mr. Markowitz was the initial author. And so there was no change in it.
Did Mr. Markowitz authorize your client to put his initials on the so-called joint pre-statement? Did he authorize that?
Well,
Answer yes or no, please.
I would say yes, it was authorized because that's what he sent her.
And did Mr. Markowitz authorize your client to type his full name as a sender in the certificate of service of that document? Yes or no?
No, but a certificate of service, if you read, yes, I hereby certify that a copy of the foregoing goes to X, and that was.
And was this document submitted to the court?
The document was filed in court, but his signature is not on the document. The mere fact.
At this point, I want to make sure we have not lost Mr. Tiger as a member of this hearing. Is anyone aware of whether we have?
It looks like you may have some technical difficulties. He can, there's a recording that he can watch later.
Okay, are the parties, if Mr. Tiger is unable to participate, are the parties okay with us proceeding and Mr. Tiger will review the recording?
Yes.
No objection from disciplinary counsel.
Thank you.
Mhm.
I may have interrupted you, Mr. Howard.
Mhm.
And Mr. Howard, you said that you don't object to Mr. Tiger relying on the recording.
If you indulge me one moment. Thank you. There is no problem with Mr. Tiger reviewing the tape. No objection.
Okay, thank you.
Mr. Howard? Just want to ask if I'm understanding this procedure correctly from my own experience with joint trial statements over the years. So I understand that the plaintiff creates this initial draft. Is that what happened here? And that opposing counsel states what plaintiff's position is on the various items that the parties are being asked to address in the joint statement?
Yes.
And then he sent that over to the respondent, you say at 9 a.m. on the day it was due? Am I right so far?
Yes, somewhere in at 9 o'clock.
And, then your client plugged in the defendant's portion. She's not there editing what he wrote, right? She's just plugging in her client's position on the various issues as well.
Yes,
And she sent that back to him at 11.
yes,
Is that what she ended up filing before midnight that evening?
yes,
What she had sent him at 11 o'clock?
yes. No difference at all.
Thank you.
Mr. Howard, if I could just follow up on what the chair was questioning you about. The matter, the joint pretrial statement was filed in court.
Yes,
And Judge Wingo did find that the court was misled by that filing, it not being in fact a joint file. Is that correct?
no, the court wasn't misled.
Excuse me.
I said the court was not misled. You know, it's my reading was that the court indicated it was not a joint statement and she struck the statement. But it was not that, you know, the court had been misled. If you look even at the face of the joint pretrial statement and the signatures, Mr. Markowitz's signature was never on the joint pretrial statement from the time he sent it at 9 a.m. until the time that the joint, you know, the document, the joint pretrial statement was filed. And so there was no difference in the language or its presentation. And then
I understand that, your position, but it clearly appeared that the Judge Wingo, felt that the court had been misled in striking that.
I can't agree with that. I mean, you know, in terms of what was in the judge's mind, I know that in the order, there was no indication of being misled.
Mr. Howard, you've reserved 5 minutes for rebuttal. I want to make sure, however, that you've addressed what you want to address in your initial argument. And maybe if there are other points, take a couple of minutes to get to those.
Oh, I shall. In the Office of District Counsel's case, an expert witness was engaged. And during the testimony of the expert witness, and that was Ms. McKinney, she explained that she was providing her expert services because she felt an obligation to help the Office of Disciplinary Counsel and is charging a reduced rate. That is not the responsibility of an expert witness. And in this particular case, the expert witness was someone known to Assistant Disciplinary Counsel, you know, both for social and professional relationship. The expert witness did not examine the Box.com in making a ruling regarding the competence of the presentation of discovery. And it just doesn't seem as if.
Is your position that the expert should have gone through and checked to see that every document was there and could not rely on the court record and what the judge found in sanctioning and defaulting the respondent? Could not rely on that, but had to review each document?
Well, I think that if someone is going to offer evidence to support a charge of incompetence, there must be someone who looks at what was produced. It was not those instances of those cases where a party did not participate in discovery, or it's rather obvious that you look at a piece of paper and it, you know, was purported to be for X and clearly it was for Y. Here we've got a box, the repository that was supposed to be the transparent record of information that goes into it, and not a single viewing by the expert witness on the quality of the presentation was ever done. You don't need to have an expert witness to regurgitate what someone else concluded. The expert
Would be the judge. Right?
Well, the judge is not
What the judge found as to the quality of the documents and the ability to find those documents when she requested.
But one doesn't rely on the judge to set a standard in a disciplinary proceeding. The judge had a view but that was even unsupported. The judge didn't look in the box.com, and the judge did not render an opinion regarding the competence of the respondent. And so I don't think that you can rely on the judge's statements to be the same as what the board seeks to find regarding a violation of the, rules on professional conduct. So that kind of reliance, I don't think, would be appropriate. If an expert witness is called in, the expert witness is supposed to look with a clear eye at what was done and render an opinion, not to regurgitate what the judge thought.
Mr. Howard, I think you started with the arguments about the expert, and you're reiterating them now. Any other points before we turn to Mr. Metzler?
Indulge me 1 second. In the proceedings, especially those proceedings that followed Judge Wingo, the complaining witness offered a statement in closing argument that indicated that his client made, I think, $60-something thousand per year. And that was after him having knowledge that the client made $90-something thousand a year, close to 100.
Information about the $90-something thousand, $99,000, is that in the record, or are you bringing that to the record?
No, it's in the record. It's in the record. That was, what the complaining witness in this case told the judge. It was only after the respondent engaged in an analysis of documents, because it wasn't, let's say, clearly stated that it was 99,000.
How is that, just succinctly, how is that relevant to this board's review of the hearing committee's report and its review of this matter?
It gives the board an idea of what dishonesty looks like. Dishonesty didn't look like filing a joint pretrial statement with the precise language from the opposing counsel in the document. His signature wasn't on it. The case that was cited was In re Claire. In re Claire, there was a signature on the document. And usually for this kind of charge, if you're going to say someone forged a document, a signature has to be present. There was no signature of opposing counsel.
Two things about that. One, forgery was not charged or found. And two, isn't that the case here? There's no charge of forgery.
Well, it was argued in the respondent's brief. The hearing committee didn't, it was a little, the way the hearing committee viewed it was to insist on /S/ was being hyper-technical. And part of the charges levied against the respondent is the respondent didn't follow the rules. And so the two can't exist in the same space. The respondent followed the rules.
What was intended by the initials?
I didn't hear
What
you.
was intended? What did your client intend by putting opposing counsel's initials? You say it wasn't a signature, she put his initials.
Well,
She
that's,
to convey to the court by doing that.
no, that was the way she received the document at 9 a.m. And she gave the document back the way she received it. She did not add any information to it. It was already there. There was no addition.
Sponsored that document, is that correct, before the court?
She sponsored it, by the filing of it, but she did not change the content of the document.
But counsel, in that footnote 45, the hearing committee did in fact decide it was not going to hear these hyper-technical arguments about the proper format for a signature. Was the court misled? And that was all that the hearing committee was looking at, not these quote hyper-technical arguments about the proper format of the initials.
I certainly didn't perceive that footnote that way. And I thought the use of the word hyper-technical was a means of getting around not actually dealing with the effect of the rule on what was on the paper.
Did your client intend to communicate to the court that opposing counsel had consented to her filing the document jointly?
I think the way the testimony was regarding is that the respondent looked at the judge's order and said, it said, you shall file a joint pretrial statement. And the information that was in the joint pretrial statement was the information that both parties had agreed to. There was no difference in the information. And
The
so,
client knew at that point that Mr. Markowitz had filed a separate statement and did not seem to believe a joint statement was necessary.
well, we find ourselves in sort of, a field that's established by Mr. Markowitz. The respondent is trying to adhere to what the judge required. Mr. Markowitz is, as far as I remember of the pretrial statement that he filed, was identical in those sections, what I call the more substantive information. Mr. Markowitz added some hyperbole about the interaction with the respondent, but that had nothing to do between the information shared on client A, Ms. Markowitz was Ms. Berry, his client, and respondent's client, Mr. Berry. There was no shade between the two. The only difference that I recall is that Mr. Markowitz, let's say, had some bad expressions to say about counsel. And that's what was placed in the pretrial statement that he filed. Everything else, I think, is identical.
Mr. Howard, you're going to have your 5 minutes of rebuttal with be held in reserve. And I think, why don't we move on now to hear from the Office of Disciplinary Counsel.
Thank you.
Thank you. Mr. Metzler.
Good afternoon, and may it please the board. Jack Metzler for the Office of Disciplinary Counsel. So the chief violation in this case is the dishonesty and the violation of 8.4C, at least for sanctions purposes. And what happened there was the submission of a document to the court that falsely purported to be authorized by opposing counsel when it was not. And I, my friend asked you to look at the document, and I suggest that you do that. It's DCX 54. And you can look, the very first words are, now comes the parties who submit the following pretrial statement. That is a representation that that both parties are submitting this statement. It's false. Yes.
Can I ask you a question about that document? Mr. Howard, in his briefing, has made the point that Mr. Markowitz is using this disciplinary procedure to get a tactical advantage in the divorce proceedings. He filed during the pendency of the divorce proceeding filed a complaint about the joint pretrial statement. How do you react to his intention that it was done to obtain an advantage in the divorce proceeding?
So, it's not uncommon for counsel to try and use our office, disciplinary counsel's office, as a tactical,
And in fact, Mr. Markowitz has done that 2 prior occasions. Is that correct?
I can't speak to what he had done in other cases. I know that he filed a complaint in this case, and our standard is we look to see whether the conduct is, if true, would warrant discipline. Now, it's true he filed this during the pendency of the case, but we did not. Our normal practice is we don't really want to get involved. We don't want to have exactly the sort of effects that my friend is talking about. And so we didn't file charges in this case until 2024 at the trial level, and the conduct happened in 2021. So at the conduct had happened years before, and I believe it was complete, although there might have been some appeals still to be had. But there's nothing inappropriate about, particularly where in a case like this, where the misconduct is documented by an order of the court. And as we started to investigate, there were, more and more indications. Now, I'm going to take your question as and also address some of the other allegations that are in the brief. And there's a number of them that say things like disciplinary counsel was secretly talking with the judge, or we were taking the side of Ms. Green's opponent against her client. And the hearing committee found that there was absolutely no evidence for any of that, including the statement by my friend that with regard to the relationship between the assistant disciplinary counsel and the expert. The hearing committee found that there is no evidence of that presented. And just to reiterate the standard, because I think it actually pervades a lot of the arguments that you just heard, the board reviews the findings of fact from the hearing committee for substantial evidence. And so the board's task then is to look at the finding and see whether there is evidence in the record to support it. Now, these allegations didn't have any, there is a finding, or at least a conclusion, that these allegations didn't have any evidence. And I didn't see anything in the brief other than attorney argument that would support them today.
Is that specifically to the argument about Mr. Markowitz obtaining a competitive advantage?
Well, I mean, I don't know what the, I can't speak to what his specific objective was. That could be true. I don't know if there's a finding about it, but I don't think it has any effect on the board's analysis of either the facts or the conclusions of law that were before the hearing committee.
Do you agree that the client was not harmed in this case?
Pardon?
Do you agree that respondent's client was not harmed or suffered any prejudice from the
No.
challenged conduct in this man?
That the respondent's client. No, I do not think that is true. One of our exceptions to the hearing committee's report is in its sanctions analysis, it suggests that there was no prejudice to the client. And here I think the prejudice is obvious and palpable. The client was subject to 2 monetary sanctions orders and 2 orders of default. And the first default order is particularly, I think, relevant here. In that order, this is at the end of the end result of all the incompetent handling of discovery. The court entered a default judgment against Ms. Green's client on the financial issues in the case. And that included child support, division of property, and division of the marital debt.
That's not correct. The default judgment did not cover child support or custody. That was later. And that was the default judgment that Judge Higashi set aside.
No, that's incorrect, Your Honor. That's incorrect. There were 2 orders of default. The first one, it's DCX 76, I believe, and that's the default on the discovery issues. And the effect of that was there will be a hearing at which Ms. Green's opponent was permitted to present evidence and witnesses, but Ms. Green's client was not allowed to present evidence in that hearing. She was allowed to do cross-examination. And you heard my friend say, well, she looked at the documents and did some cross-examination on the opposing party and was able to show that his statement about his income or something was wrong. Well, in that hearing, because of the discovery incompetence and the rest of it, her client was not allowed to present any evidence. And so the hearing committee says, well, disciplinary counsel didn't show that if he were permitted to put on that evidence, he would have gotten a better outcome. And our submission is that is not the standard. Prejudice includes the right of a party to put on evidence. And if that is taken away, that is prejudice to the client.
Clearly, but as I understood it, the first default judgment went to the marriage and to alimony and to property.
Oh, was your question about child support specifically?
Child support and custody was the second matter in which
So-
the client was allowed to.
Okay, so I will correct myself. I'm not sure about child support. I know the second one was about custody. And so, but as to standing here today, I think that custody was, not custody, but support, that the financial issues were all part of that first, but okay. But I stand corrected if that's the case.
Mr. Metzler, central to respondents' argument here today, and also central, at least in their reply brief, is the position that the expert witness testimony, conclusions, and really, it seems the determination of the fact finders is somehow tainted or impacted by the fact that the expert did not review the entirety of what respondent produced in discovery. And somehow that's a failure here. Can you please, how do you respond to respondent counsel's argument to that effect?
Sure. I think I've got 3, maybe 4 answers to that. The first one is what I was saying earlier. The hearing committee made findings on this. And so the board's task is to review those findings and see if they're supported by substantial evidence. And the substantial evidence here can be found in the court's orders. And again, I invite you to review them. The orders on discovery are the sanctions order, which is DCX 40, and then the default or the order on the default, which is DCX 76. And if you look at those, you will see that the court went through in great detail and talked about not only about information that was missing, about the efforts of opposing counsel, of Mr. Markowitz, to get that information. And it included, and just to be clear, this is not just about the production of documents. The entire argument that, even if it were possible for the hearing committee or the board to go through and figure out what was and what was not in the production that was uploaded to Box.com, a task that the district court, which was much more enmeshed in it, threw up its hands and decided it couldn't figure out. Even if that were true, the court's order is based on failing to provide written discovery as well. So, for instance, you'll see in those orders, he was asked things like, "What is your credit card balance?" And I'm sorry, the opposing side asked things like, "What is your credit card balance?" And Ms. Green continually failed to provide that information. Now, it's true. She could have said, the credit card balance is in the credit card statements, which you can find at wherever. She didn't say that, but she also just didn't provide the information. And the court's order goes through a number of these, and they're very detailed, and it's all in the footnotes. And the conclusion was not that she didn't identify, that she didn't actually provide those things. And as the board was suggesting earlier, the obligation is not just to pull up a dump truck and say, well, it's in there somewhere. The obligation of counsel in responding to discovery, and this is what the violation is based on, reasonable response to discovery is the language of the rule, is to produce the material in a way that the other side can find it. And, just to be clear, the court took an entire day of its schedule during COVID to go through and try and figure out, is Mr. Markowitz correct about the things that he says are not there? Or is Ms. Green correct about the things that she says aren't there?
Excuse me, Mr. Messler, so during respondents' presentation, they made the argument or suggested that the court itself didn't go through the materials. Is it your position that the detailed court orders established that the court did go through the materials to some degree?
It's our position that that argument is a non sequitur. The question before the board is whether the findings that the hearing committee made are supported by substantial evidence. And you can find the substantial evidence in the testimony or in the orders of the court. And I'm just sort of saying for your information, they are very detailed and they tell you things that were actually missing. There are findings those are substantial evidence that support the hearing committee's findings. And so the court should, or the board should adopt those as well.
Mr. Metzler, can I jump ahead to a slightly different subject that you were bringing up, deals with sanctions? You're seeking a 1-year suspension with none of that stayed.
That's correct.
In a case that is not on all fours, but in Ray Reback, which involved the divorce proceeding and where there was a falsified signature, the hearing, the board recommended 1 year, and the court knocked that down to 6 months. Could you explain what is different in this case that would justify an upward departure to 6 months?
Sure.
To a total year?
Yes. So in Reback, I agree. It's a very similar factual circumstance with regard to the dishonesty. They both involve submitting to a court a document purportedly with the authorization of someone that did not actually have that authorization. And this actually fits quite neatly with my friend's argument. He says, look, well, the document was exactly the same. In Reback, it was literally the same document. Their client had signed that. It was a verified complaint. Their client had signed it through inattention. The complaint was dismissed for failure to prosecute. And so they re-signed it without telling anybody, Reback and the other respondent in that case, and submitted it as if it were genuine. It was literally the same document. Nevertheless, the court found that is a violation. It is a violation of the attorney's responsibility to be honest, and it's a violation of the procedures of the court, the reliance that the court has to place on attorneys' filings. So the difference, though, and if you read Reback, it's very clear on this. The court sort of wrings its hands a little bit. It says this is the first case where we're going to decide what to do when an attorney files a false document like this. And it says, well, yes, this is very serious because of the dishonesty, but these two respondents have been in practice for decades, and they've never had anything happen before. When this happened, they said, we are so sorry. We really messed up on this one. They gave the client's money back. They exhibited remorse, and the court said, okay, given all of that, we think the very minimum sanction that would be appropriate to protect the public is 6 months, and there was no stay. So that would be the first distinction. Now, in addition, the difference between that case and this one is Reback didn't have an extended course of incompetence, of missing court deadlines, of failing to show up for hearings. It didn't have monetary sanctions entered against them. Those attorneys had unblemished records. They didn't have prior discipline like Ms. Green has. So they're building up multiple factors that aggravate the sanction here, and including the additional dishonesty of representing to the court that the discovery was complete when it wasn't. So all of those things sort of add up. And if you then compare Reback, 6 months, no stay, to this case, where it's 6 months, half of it stayed because the hearing committee, it may not have recommended fitness. It sort of had this conditional statement. If she can't do these things, we think she probably should get fitness. It had serious concerns about her ability, which is why it recommended a practice monitor, consult with practice management advisory service, and so forth. But it took those concerns.
In this case, the hearing committee found there was no actual prejudice to Ms. Green's client.
I mean, I think that is wrong as a matter of law. I think it is, it's incredible to say that a default entered against a client who goes to a hearing and is not allowed to present evidence, that's not prejudice. I think it is incredible to say that when there are monetary sanctions, the client had to write a check they're saying that's not prejudice. And actually the second order was only a few $100s, but the second sanctions order was based on Ms. Green didn't show up to a hearing on her own motion. And then when she finally did show up, the court called her on the phone. She was not prepared to argue it. So it's true. The client also didn't show up for that hearing. And it's true. The sanction was imposed on both of them. But it is very hard to see how the client wasn't prejudiced when an attorney doesn't show up for the hearing and cannot argue her own motion. So I think the prejudice is just wrong. But even setting that aside, the prior misconduct, the scope and number of violations in this case distinguish it from Reback. And I would be remiss if I don't mention the lack of any remorse. Unlike Reback, who they just acknowledge, yeah, we were in pressure, we did what we shouldn't have done. There are 12 pages in the reply.
Then, as long as you're talking about that, how Adobe plays into this, by the number of violations here.
Sure. I mean, our argument on that case is very simple, which is that when there are in Adobe, they say the number of violations isn't that important, or the number of rules violated isn't that important when it's all basically, the same conduct. That involved a Brady violation on behalf of prosecutors. You could look at it a couple of different angles, but it was all the same thing. Here, we would say the conduct is, there are several categories that are quite different. The dishonesty, for example, has nothing to do, I mean, the discovery stuff, was long and extensive. That is basically one course of conduct. But the dishonesty, I think, is completely separate from that. It didn't result from the failures in discovery or anything else. And likewise, just missing court hearings when you should have attended, the serious interference with the administration of justice. That's also separate. So that's just another factor that sort of ramps up the sanction. But I do want to get back to your original question. Just you asked me to compare Reback to this case. And if you compare the two, I'm just going to start with the hearing committee's recommendation. In Reback, there was no requirement for there was no stay, no requirement for a practice monitor. There was no doubt those respondents were going to be that they had any ability to there's any detriment in their ability to adequately represent people in the future. Here, the hearing committee had serious concerns about it, but instead of saying Reback plus, it said Reback minus. In effect, the hearing committee is rewarding Ms. Green for her incompetence. She gets a shorter suspension and time to fix the things that are wrong with her practice, rather than Reback, who was going to immediately go back to presumably ethical practice, and yet had to serve a longer term of suspension. So I think that at a minimum, this is a Reback plus case. It is not a Reback minus case. Now, with regard to whether the stay is appropriate at all, our position has been that there are circumstances that justify a stay, and circumstances that, and other reasons that don't. In prior cases, we said, well, it has to be only circumstances that lessen the culpability, and the court didn't really go along with that. It said, well, it could also just be that there are mitigating circumstances that might lead you to enter a stay. Here, those kind of mitigating circumstances don't exist either, and there's nothing that suggests this was not Ms. Green's fault. So we think a stay is inappropriate in any case, but it is particularly inappropriate where in order to implement conditions that respondent says she does not need, right? So the part of the lack of acknowledging responsibility here is she thinks all of this is fine. Like her brief says, having defaults entered against your client, having sanctions ordered when your client has to write a check, this is all just litigation friction. Either that, or it's the fault of opposing counsel, or it's the fault of the judge. And this should all be fine. And, you know, our submission is it's not fine. Even the hearing committee recognized there's something that really needs to be improved here. And so this is why we recommended that, yes, she should have these conditions, but make those part of the suspension, and let's certify that you have talked to PMAS, that you have implemented their suggestions, and you allow them to talk with us before you are readmitted, rather than lessening the sanction so that you could.
Actually, you're not asking for kind of backdoor fitness requirement, are you?
No, I think what we're asking for is really not that different from other conditions. You know, for example, if you order, if a respondent has to do CLE, you know, that's something where it's pretty, they do it, they prove to us that they do it, and then when they come in and seek reinstatement, we say, yes, we're satisfied they did what they were supposed to do. And likewise, consulting with practice management advisory service and implementing their recommendations is the same sort of thing. It would not be fitness in that it would not involve a proceeding in which Ms. Green would have to prove by clear and convincing evidence her character and all of the Roundtree factors that are involved in that. We aren't arguing for fitness in this case. So just a couple of more points. One thing I wanted to mention with regard to the dishonesty is, you heard my friend say that, well, this isn't really dishonest because it was the same document essentially, and there wasn't any signature. And you know, I have to say that strikes me as worse than just admitting that this was dishonest from the outset. That position is basically, it is okay to say, as long as you don't sort of sign the person's name or use an S, you can otherwise indicate to the court that the document is approved using things that don't meet this technical definition, and it's fine. Like it's not only it's like a worse, let's say a less bad version of the of dishonesty. They're saying it's not even dishonest at all. And again, I would just ask you to look at DCX 54 and just look at the last page of this, because I think this is actually quite relevant. The certificate of service. Now, there's an argument in the reply brief where they say, you know, you always have people's names on a certificate of service. That how can you show that you served them otherwise? But that's not what's going on in the certificate of service. It says, we, counsel for the parties, hereby state that on this day, a copy of the foregoing joint pretrial statement was served via case file express on the court. The listing below isn't who got served. It is who is certifying, who's making this statement. And then both names are there and they're underlined. And I think any normal person looks at that and says that's supposed to be their signature. Look at the page before, respectfully submitted in slashes JNM. Well, you know, I have to admit that I've always liked the form S/. I don't like the 2 slashes. So if you look at my briefs, they all say S/. But I'll represent to you that is meant to represent my signature. And this form and yeah, the representation from my friend is this is what she got from Mr. Markowitz. So he intended it to be his signature. And then she didn't just copy and paste, like I think I heard. She just forwarded on what she received. The testimony and the findings are she retyped this. She typed /JNM/, and she typed his name and made sure it was underlined in the certificate of service. So
What's your next remaining point?
let's see, I may have one. Okay, so I did want to mention, I would be remiss to not mention that in the reply brief, there's an accusation on page 4 that disciplinary counsel has taken words from the opposing counsel, Mr. Markowitz, and put him in the court's mouth. And that is absolutely false. We cited findings of fact 41, and that finding, I'm sorry, we didn't cite, we quoted and cited findings of fact 41, and that quotes DCX 41, and those are the court's words. So the accusation that we are misrepresenting the record is absolutely false. And I did just want to, in response to Mr. Brozos' question, I wanted to point you to, with regard to whether the court was deceived, I want to point you at DCX 59, page 16. And that is, that's the hearing on opposing counsel on Mr. Markowitz's motion to strike the joint pretrial statement. And the court says, this absolutely falsely suggests to the court that he has approved the document, which he has not. Now, I don't know whether the court was actually deceived because it probably didn't look at the document until it got Mr. Markowitz's motion to strike it. But the court clearly found that the document itself was false and falsely suggested that Mr. Markowitz approved it when he had not. So I guess the last point I would make is that I heard a lot. There's a tenor of the reply brief, and I heard in the argument, that Ms. Green had some other success for this client, and that should somehow mitigate, or it means that there weren't any violations. And I would just say that the court has held that success for the client is not a relevant factor that we consider. The questions are whether the facts are established by the facts are supported by substantial evidence, and the conclusions of law are, that the facts add up to the conclusions of the violations. With regard to the testimony about that particular $90,000, the amount that was earned, just like to point out that was cross-examination. That was at the hearing when Ms. Green was not allowed to present her own evidence. And that's just a further indication of the prejudice that her client suffered. So adding it all up, we think the factors that aggravate the sanction, that distinguish it from Reback, merit a longer period of suspension, that it should not be stayed, but that Ms. Green should be required to fulfill the conditions that the committee recommended.
Thank you, Mr.
Thank you.
Chancellor. Mr. Howard. You have 5 minutes for rebuttal.
One statement that I made during my argument, I have to stand corrected. The last discussion regarding the $38,000 difference between what Mr. Markowitz said and what was actually borne out in the facts, that was on direct examination and not cross-examination.
Thank you.
And that and the witness was Mrs. Berry that occurred. One of the things I'd like to go back to is the In re Reback. In re Reback was not a circumstance where there was a dispute between, let's say collaboration with lawyers. This was lawyers who attributed something to, let's say a layperson, a client. And this has no resemblance. There was absolutely a signature on the verified complaint that was not the signature of the client, and it was placed there.
Mr. Howard, I understand your argument, but in this case, did not the collaboration on the joint statement collapse when the opposing party filed his own statement that was not joint? Doesn't that wipe the jointness out?
From a case-wise, it wipes the joint out, but not from a disciplinary violation. That is not dishonesty to submit a document and the language in the document came from the other person.
But I don't think we're debating here today the veracity of the words in the joint statement. I think the issue to address is the effect of filing that joint statement, proffering it as if opposing counsel joined into that statement, when in fact he had filed his own statement, and then the court even makes a remark, as disciplinary counsel pointed out, that there was an element of misrepresenting or misleading the court.
I agree that the language was in the order, but it is not the type of circumstance that you measure with In re Reback. There was no signature attributed to the parties to the document. And when you start saying, well, disciplinary counsel says this is the foundation for a dishonesty finding, we do not believe that that is such a foundation, and it does not mirror the circumstance in In re Reback. There was no signature. We do still have to abide by and give credence to the rules of the court. The rules of the court say you sign, you put S/S/, and there was no signature attributed to the respondent, to the opposing counsel. If you note on the joint pretrial statement, the respondent signed her name, S/S, and she indicated her name. And that's the only signature.
Position, Mr. Howard, that if respondent would have written S/S and then the full name of opposing counsel and proffered that document to the court, then we're in a world of dishonesty. But since initials were used, we are not in a world of dishonesty.
But even the /S, was not before the initials. And the way that the rule says you have to sign the document. Ordinarily, items like that, the clerk of the court would kick it back to the filer. But
Mr. Howard, is there any conduct at issue here that your client has at any point acknowledged was wrongful conduct? Has your client in any way accepted any responsibility?
that always presents a challenge for one to articulate, because in disciplinary proceedings, the attorney is attempting to offer.
I understand. It's
Correct.
really just a factual question.
Correct. But at the heart of it, the respondent is aware you have to attend hearings and you have to attend and you report to the court timely. That is not, there's no confusion about that. Now, I can tell you when it comes to the discovery and the analysis of the discovery, the court did not make a finding, and nor did the hearing committee, that the items that may have been missing were in the possession of the respondent. This was not the respondent's. The respondent was not a party to the case as a litigant, and was not the repository of the information that was being demanded. The respondent has to give the interrogatory, give the request for production to the client, and the client is the one that provides the information. And so here, there has not been that distinction made about what it was that the client provided or what it was that the client didn't provide. The only representation is that the respondent says what information was demanded, what information was requested, and that I received from my client. I have submitted it and submitted it in the proper form.
So Mr. Howard, are you suggesting that in the course of practicing law, when a lawyer is submitting discovery in part of litigation and they get the discovery from their client, the lawyer is completely inoculated around whether that discovery includes bald-faced lies, if it's missing documents, if it's created documents that are not legitimate? The lawyer is only a courier of the document and owns no responsibility for the veracity or completeness or organization of those documents.
No, I think you're going a little bit too far afield with that one, because you have other problems if a client is not being honest, and a lawyer has to sort of weigh whether or not they're going to actually be involved in the matter. But this was not that kind of case. There were some documents, if you look through the record, there were at least 13 supplements to discovery. So with that supplementation means at day one, all of the information wasn't there. And, you know, it came in over time. But there's never been a finding that the respondent withheld any documents and didn't, you know, supply them timely. Far as the record is concerned, whatever the respondent received, the respondent submitted it. And those documents that were on her list that went into Box.com, they were submitted in one fashion. The client himself submitted some additional documents and used a file name description. And that's what was, you know, in the box. But we don't believe that, you know, with the facts in this case, where the client received relief that was certainly better than what the opposing counsel was attempting to suggest upon the court. And in In re Reback, it was not the same. There was no fault in the relief that the respondent's client received. The respondent's client still has engaged her in an appeal of certain issues that occurred. And so we don't see anywhere that there was any prejudice. We think that the factual finding made by the hearing committee is correct. There was no prejudice, and whether or not there was prejudice or not is not a legal question in this sense, what disciplinary counsel seeks to try to couch it as.
Can I just ask,
Sure.
though, Mr. Howard, you say there's no prejudice. Respondent's client was forced to pay at least $2,500 with the two sanctions.
Right. The reason I make that statement, certainly parting with money, no one wants to do that freely. Whose fault was it that whatever the court attributed to being an absence of discovery, was it the respondent's fault or was it the respondent's client's fault?
Mr. Howard, was it just the discovery, or wasn't it also failure to appear at a hearing? And wasn't your client's client being informed, or didn't your client fail to inform her client of what the schedule, when that hearing was scheduled, the December 20 hearing? I mean, it's not all just discovered. Didn't the failure to appear also factor into it?
Well, the sanction was only for the June hearing, meaning the monetary sanction. It was only for the June hearing where the respondent reported after having received a call from the clerk. The December 20 hearing was not the largest sanction. I think that was, if I remember correctly, $288.
That was, but in March of 2021, there was a sanction for $4,400.
That and that pertained to,
That had to do with discovery.
yes,
To meet the obligations of discovery.
that's the way that was termed. Yes. Right.
Mr. Howard, your rebuttal time has expired. You have a wrap-up argument you want to make?
My notes expand the amount of time here.
In the interim, I'll ask if any board member has any addition. Mr. Howard, conclude.
I'm going to conclude on one item that disciplinary counsel indicated that there was dishonesty in communicating with the court, or something outside of what was actually charged. There was nothing charged other than the dishonesty that was attributed to the filing of the joint pretrial statement. Everything else was not charged. And the respondent understands her responsibility to the court and the client, but some of what's being attributed to the respondent would have to be parsed out with and understand that what was it that the client gave to the respondent. And that's absolutely missing from this transcript. No analysis of Box.com to understand the quality or the caliber of the presentation or the information that was produced. And we don't believe that this falls in any case where a respondent receives a successful result, where disciplinary counsel is involved in different aspects of the case. When this case was filed, it was based on the joint pretrial statement. The investigation moved all the way up to March 2020, and then all the way into February 2025. We were in the midst of a hearing. Another motion for attorney's fees came through electronically to the proceedings, and that was being offered as an exhibit in the case. I've never seen anything like that occur. And we believe that disciplinary counsel compromised the respondent's effectiveness by facilitating all of these machinations that came from Mr. Markowitz.
Thank you, Mr. Howard.
Thank you.
Case is submitted.